business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-1042, EDA, Husky Marketing and Supply Company, petitioner versus Federal Energy Regulatory Commission and United States of America. Mr. Wagner for the petitioner, Mr. Ediger for the respondents, Ms. Kohlhausen for the intervener.
Good morning.
Good morning. And may it please the court. FERC set the Ozark application for hearing to give Ozark an opportunity to demonstrate that it lacks the ability to exercise market power in an appropriately defined destination market. The ALJ assembled a substantial record and conducted a lengthy hearing. FERC's expert trial staff analyzed the options available to Ozark's shippers. It considered a competitive price for transportation to Wood River, the delivered prices of crude oil by various transportation routes, the identity of the shippers and where they consume crude oil, and the fact that Ozark's largest shipper by volume is its affiliate, and concluded that if Ozark attempted to exercise market power, its shippers would not shift their volumes to a location other than Wood River, and therefore that the destination market should be limited to the pipeline's terminus at Wood River. The ALJ agreed that Ozark had failed to meet its burden to establish a broader destination market than Wood River. It found that Ozark had the ability to exercise market power in that Wood River destination market, and she recommended that FERC deny the application. FERC then put that evidence to the side, did a 180-degree turn and said that no quantitative analysis is needed to identify the destination market in which Ozark faces competition. Found that Ozark's burden of proof was satisfied by the observation that some of Ozark's volumes flow downstream to Patoka and beyond. And on that basis, FERC determined that Patoka must also be part of the destination market, and that every pipeline delivering to Patoka is necessarily a good competitive alternative to Ozark. And FERC ultimately found that Ozark does not have the ability to exercise market power over deliveries to the combined Wood River-Patoka market, and granted the application. FERC precedent provides that when geographic markets are contested, the pipeline must justify its markets and competitive alternatives based on detailed cost analyses. By detailed cost analyses, FERC is referring to the costs of the pipeline's shippers. For example, in the TE Products case where that...
Since TE Products, the Commission has said on numerous occasions that other methodologies can be used.
Well, it's said that other methodologies than a hypothetical monopolist test may be used, but as far as whether a detailed cost analysis is required, I don't believe FERC has cited a single case, a contested case, in which they had found until now that such an analysis was not needed. The Commission cites several cases.
Does that make it wrong?
I'm sorry?
Does that make it wrong? That
Yeah.
This is the first time, as long as their analysis reasonably captures the relevant economic considerations. And I'm sure you disagree with some of that, but if it does, then what would be wrong? And it follows a pattern of decision-making they have done in other cases, not contested ones. What would be arbitrary or capricious about them doing the same here when you have, clear track record of what the business is like at Wood River and Patoka and between Wood River and Patoka, and they made this sort of factual findings.
Sure. Well, two things. First of all, just about the prior cases, FERC has said that it does not scrutinize uncontested applications. So any principles that it might establish in one of those cases or evidence that it accepts in one of those cases doesn't establish principles for contested cases.
That's the one case to which you referred a moment ago.
TE Products.
No. You said there's been one since then that when I mentioned the FERC has said several times numerous different methodologies would be acceptable. I think you said those were in uncontested cases, save one.
Oh, I think I must have misspoken then. I don't have a case in mind.
All right. Well, let me ask you to clarify for us, please. If assuming for the moment anyway that FERC is correct with regard to the geographic market determination. Are you separately challenging FERC's determination that Ozark does not have market power within that expanded market?
No, if the destination market includes Wood River and Patoka, the HHI does indicate that. But to go back to Judge Millett's question, I think that the relevant commercial realities, which all parties agree that commercial realities are relevant, we don't agree on what those are. Any consideration of commercial realities must include the delivered price. This court has recognized in the Mobile decision that delivered price is the real economic concern of shippers. One of the essential questions a shipper would ask when considering an alternative is, how much will it cost? And without doing that, I just don't believe that there's a complete set of relevant commercial realities being examined.
Given FERC's finding that most of the oil that goes into Wood River continues on to Patoka, you don't dispute that fact?
We don't dispute that fact, but there's a very
Why
important
doesn't that
context.
There's
There's very important context to that fact.
Okay, but why doesn't that, given that most travels between the two of them, why isn't that a particularly salient fact in defining the relevant destination market as including both Wood River and Patoka? It would be rather artificial to treat it as just Wood River if most is just passing through.
Most of it does go through. However, most of what goes through for the pipeline's affiliate. And the pipeline and its affiliate have aligned interests. They've put that in their SEC
Very well
filing.
made. That seems to go to the competitiveness issue that you are not contesting. You just told Judge Ginsburg. But as to the destination market, as to options that customers have, I'm not sure what the affiliation has to do with on that question. I understand its relevance at the competitiveness analysis.
Okay. It has to do with the rationality of using Patoka to escape an exercise of market power. If we're not looking at the entire set of the volumes that go through to Patoka as the relevant shippers that may react to an exercise of market power, the only shippers that continue through to Patoka that may or may not react to an exercise of market power are those that are not affiliated with the pipeline.
So you're saying the affiliate would continue to pay a super competitive price because, I think you say in your brief, because its profitability is upstreamed to the partnership.
That's correct.
But the partnership, as far as we know, as far as I could tell, has an affiliate as the general partner, but there are limited partners, correct?
Yes, that's correct.
Are they affiliates?
No.
So the general partner has a fiduciary duty to the limited partners not to overpay for a self-serving reason.
Yes, however, they have disclosed to those investors, to those non-affiliated investors, that our interests are aligned. And one arm of this combined enterprise is not going to act against an interest of another arm of the
Where did
enterprise.
you say they have disclosed?
MPLX, the owner of the pipeline.
Has said their interests are aligned, use that word
Yes,
aligned?
their interests are aligned with those of the shipper, who is the largest shipper by volume on the pipeline.
That doesn't excuse them from, or does it, from their duty to the general partners, to the limited partners.
I think you also have to factor in the fact that there is a long-term contract here.
That's a completely different point, correct?
I don't believe so. I think that affects the motivations of the shipper. It has a contractual commitment to its affiliate to continue shipping on this pipeline.
With regard to price?
That's correct. Or else it will pay a deficiency fee in order to switch. So not only do they have aligned interests because of their common ownership, which I recognize is not complete, but they also have a financial tie that has cemented that through that contractual commitment with the deficiency fee. I think this actually, the commission.
How does that go? how does that go to the question of what the proper destination market is? You just look at the reality of how this product is moving and the numerous other pipelines that come in to Pawtucket. Again, it sounds to me like you're making an argument that FERC should have found a lack of sufficient competitiveness in the Wood River Pawtucket market, as opposed to that's not sort of geographically the appropriate destination market.
One of the issues here is that, and I recognize the different steps. There's the step in defining the market and the step in defining the competitors. FERC has basically eliminated the step of defining the competitors because it's found that the use of any alternative, regardless of availability, regardless of price, is going to, it shows that that is a good competitive alternative under circumstances of market power. And I don't think you can make that leap from current use to what would happen if the pipeline attempted to exercise market power. That's the cellophane fallacy, that prices in a market are assumed to be competitive, and the choices that customers in that market make are assumed to reflect that competition. I think if you only look at a map and you only look at the shipment patterns under current conditions, that doesn't tell FERC what would happen, what would be rational in the exercise of market power. Briefly, there are the three groups of shippers. I think we could set aside the people that stop at Wood River, and we've got the affiliate, which is the lion's share of the capacity. It's not rational for them to shift. So Ozark is not going to lose volumes to someone delivering to Pawtucket.
Well, FERC said there's a significant minority that aren't so bound, and by significant, signify that they would care that if they were all to go packing and head to another pipeline, that would have a huge economic impact on MPLX.
I don't think that FERC can make that assumption without looking at actual detailed costs. What it's saying is, and I can't say the number because it's under seal, but I would disagree that it's a substantial amount. Those shippers.
But so is that, I mean, because FERC did undertake a competitiveness analysis, and it did address the affiliate status and those implications. You may disagree with those determinations, but again, you focus solely here on what the destination market should be, and that seems to me a narrower question than the role of affiliates in affecting or not the competitiveness of the Pawtucket River market.
The destination market analysis is the only place to contest who is a competitor to this pipeline. And what we're supposed to be doing here is to find out, is it rational for shippers to move, and would it be effective for shippers to move? The vast majority of the volumes on this pipeline are not going to move. So what you've got is a testable proposition. Would this percentage, however we characterize it.
Did you argue to FERC that even as to the affiliates, they would not move?
That's correct.
And what did FERC say?
FERC said most of the volumes go to Pawtucket. They're 70 miles apart, and they're both near St. Louis. That's all they said.
It did talk about the affiliates, and it did not fit. A lot of that goes to competitiveness, but it felt like that there were checks there.
I didn't believe that it said that there were checks there. It just said that they would not.
They would not have the checks, and maybe I'm mischaracterizing, but would not have the capacity to cause this, to interfere with their ability. The affiliate status was not going to preclude them from affecting why this should be the destination.
And
so again, it might have some impact over a competitiveness issue, but for purposes of having consumer choices, it rejected the notion the affiliate status was going to prevent that from happening. And in any event, the significant minority would have sufficient weight. That's a factual determination you can dispute, but I'm not sure what we're supposed to do with that.
There's no substantial evidence for that. It's an assumption. It's just a statement that most of the volumes go this way. So that's part of the market. And what we've said is, but you have to look at, will these people move? Will they provide incremental price discipline if the pipeline attempts to exercise market power? And the answer to that, I believe, is no, but I also don't have the burden of proof. Ozark needed to show someone is going to shift these volumes to Patoka, and it's going to hurt this pipeline. It's going to stop it from exercising market power. And our immediate response was, well, your affiliate won't do that. And that's, as I said, it's a quantitative issue. It's a testable issue, and they didn't do it. There's no substantial evidence to support that this pipeline would suffer if it raised rates on its affiliate. And there's no substantial evidence that shows that this pipeline would lose any volumes if it raised rates on the small, the group of small shippers that continue to Patoka and aren't affiliated. That's the crux of the case. That's what's missing substantial evidence. It's just an assertion. They could go over there. That's just a map. That's not.
I'll ask you this.
Yes.
Repeatedly, the commission says we looked at the market realities. And the record contains some confidential business information that I presume is the market, part of the market realities. And just assuming that that there's a significant flow of crude in both directions between Patoka and Wood River. Why is that? Just, I think you tried to explain this once, ask you to try again. Why is that not indicative of the being in one market?
The back and forth flow? Sure. For one thing, the flow from Patoka to Wood River is actually quite small. If you look,
Why?
it's actually quite small. It's, I believe, don't know that I can say the number. It's a single-digit percentage of the refinery's capacity at Wood River. And if Wood River itself is the destination market, that pipeline, that Capwood pipeline that comes from Patoka to Wood River would be one of the competitive alternatives. But what FERC has done is not only is Capwood that comes in from Patoka a competitive alternative, but everything upstream of it is too. And that doesn't make any more sense than going to the source of any of the other pipelines that lead in to Wood River or to Patoka.
Well,
we have Canada.
So the upstream of Capwood were large capacities coming in from 2 or 3 other pipelines. And so a shipper could, I think their point was a shipper could route the throughput into Patoka through those carriers. Is that correct?
That's the assertion, yes.
And you're saying that's not significant because they can't get to Wood, because there isn't enough capacity to take them to Wood River?
I'm saying there is some capacity there. It's not very significant. And the way that should be treated is to treat the Capwood pipeline from Patoka to Wood River as a competitive alternative, not to look upstream of it any more than you look upstream of the other competitive alternatives. We don't.
Well, I mean, as you were suggesting, it's a bottleneck on the way to Wood River.
That's one way of putting it, yes.
And I don't remember, did the commission take account of the possibility of shipping beyond Patoka, not to Wood River?
Yes, I think so. In a narrative sense, they took account of that. They described it. They didn't do any quantitative analysis. But yes, those small shippers that continue on to Patoka, as far as I'm aware, no one stops at Patoka. You continue on to Ohio and Illinois and other refineries in that direction.
Right, so they could get to Patoka and then beyond, assuming there's capacity on those other carriers.
And that is one of the assumptions that FERC made, assuming there's capacity. That's right.
And am I correct in recalling that in a market that doesn't have a high HHI, they don't get to the question of capacity?
There are a couple different ways to look at
you
capacity.
said that.
Yeah, they don't look at, you can look at capacity as a sort of secondary factor if it's a close case, but you should also look at
But that
availability.
implies that they don't look at it then if it's not a close case, right?
But they're supposed to. because a competitive alternative is one which is readily available.
So you're saying they should be dealing with it twice?
They should consider whether there is available capacity in order to name something, to designate something as an alternative or a location as part of the market. And then if at the end of that, you do an HHI and it comes out to the knife's edge at $24.99, then you can look at it and FERC can make some sort of qualitative judgments and say, okay, this falls on this side of the line or that side of the line. It's relevant to both inquiries. You're not a competitor unless you're readily available. And that sort of fact can be taken into account in the end as sort of a tiebreaker type.
So you're saying they say they're looking to where a shipper could turn and ignoring that there may not be sufficient capacity to turn there.
Not just ignoring, but the pipeline had the burden of proof to show that, and FERC let them off without doing so.
We do have some data in the record about excess capacity. I don't remember. Is this confidential?
Most likely it is. I would say, however, that there's plenty of data in the record, but there's no data in the decision.
Well, I think what happened there, it looks pretty likely that the FERC was omitting references to or trying to work around a lot of confidential business information by saying repeatedly, we've looked at the market realities, i.e. what's moving around where, some of which is now before us in the green brief. It's in the record. And the FERC says that's what we looked at. I don't know why we would doubt it.
I think if they'd done that, there would be at least a citation to an exhibit or something in the record. I can understand that maybe we don't want to litter the brief or litter the decision with confidential markings and redactions and so on. But they should at least say, we looked at this here, and we all know what that means. They didn't say that. All they said was, it's enough to know that some people, or that the majority, including the affiliate, continue to Patoka. It's about 70 miles apart, and they're both near St. Louis. That's the justification for the decision. There may be plenty of
It's not
evidence.
just it's just not just the affiliate. I mean, one of your clients, all of their oil moves.
That's right. All of
At
it.
least one.
Yes, and I would point to,
So this isn't just an affiliate movement.
that's right. And my client is an extremely small shipper on this pipeline.
I'm just saying, one of them moves all of their oil onto Patoka,
That's right.
as does this affiliate.
It's
And
not about all of our oil. It's
Okay.
about how much business is the pipeline going to lose?
So how much, give a rough percentage if you can, is carried
Low
by,
single digits.
shipped by the non-affiliate that is your client?
Pardon me, low single digits. And I have it in the
percentage of
record.
What are you measuring with the low single digits?
The capacity, the used capacity on the Ozark pipeline.
From the beginning, from Oklahoma to Patoka, or are you talking just from Wood River to Patoka?
I'm talking, well, that's a different pipeline. I'm talking from Cushing, Oklahoma to Wood River, which is the Ozark pipeline, one on, one off.
Okay, between Wood River and Patoka?
I don't have that data. I'm sorry. I do have the data in the record. There it is. Joint Appendix 1278, lines 12 to 16, that discusses Husky's share of the Ozark capacity. And
I'm
if,
sorry, but is it?
What was the reference?
yes, Joint Appendix 1278, it should be in the sealed appendix.
Sorry, and this is on which segment?
This is the Ozark segment, so this is Oklahoma to Wood River.
Right, but I'm not quite sure.
It's a
But we're
reference.
trying to figure out whether the market includes not just Wood River. I need to know the percentage between, since all of that moves on, how much of, not all of the affiliate stuff moves on. How its percentile is between Wood River and Patoka?
I don't, but
And all your client, all not, I should not just your client, but all non-affiliate shippers.
Mhm. I have that number in the brief as well. That one is, wish I could say the number.
That's okay.
Or could you tell us
Point us to it.
when your rebuttal time?
Yeah, it's
Rebuttal.
in my brief. Let me find the number.
Do it on rebuttal if you wish.
And I'd be happy to. Why don't I not take the time and I'll state that on rebuttal. Well, the last thing I would just say about, pardon.
You just sum up then, and we'll give you some time on
I
rebuttal.
appreciate that. Yeah, the last thing I would say about, Husky's volumes, all of Husky's volumes. I mean, that's like saying a grocery store doesn't have market power over its customers because the Jones family buys all their groceries there. It's a matter of what is the share of the pipeline's capacity? What's it going to lose? What does it put at risk by raising its prices to a super competitive level? And what it puts at risk is very little. It puts at risk that small percentage of people that aren't affiliated with it that are going to go through.
This all sounds again like a competition argument, not a destination market.
I understand that, and that the destination
So
market.
FERC said, I mean, it did talk actually with some specificity in paragraph 27 of the initial decision about the constraints it thought on would exist, it found would exist on MPXL's ability to unfairly raise or exercise market power and increasing rates. So it did address that issue. Before that, it said, we haven't before considered affiliation as part of identifying the destination market. Customers as customers, I guess is what they're saying there. And then we'll deal with affiliation and the competitiveness prong. And I don't understand your briefs to be saying that was an error of law by FERC. You have lots of arguments about the substantiality of evidence supporting their ultimate determination of the destination market, but you haven't argued as a matter of law that FERC was wrong to say we haven't in the past considered affiliation just at this question of what the destination market is.
Sure, and it's ruled on a small handful of contested market-based rate cases. It's not surprising that any particular set of
You're not
facts.
saying they erred in saying.
No, I'm not saying, no, there's
We're
not.
putting affiliation in the competition bucket,
Right.
not in the destination bucket. You agree that's not an error of law by FERC? Or you're not contesting that?
I'm not contesting that. What I'm contesting is that in order to have substantial evidence for their destination market, they needed to account for it.
Okay.
All right, I'm well over my time. I appreciate it.
We'll give you some time on rebuttal. Thank you
Thank you
so
so
much.
much.
Maybe you'll have that information for Judge Ginsburg.
May it please the court, I'm Scott Edgar for the Federal Energy Regulatory Commission. Thank you for hearing this case this morning. I want to go directly to the discussion, Judge Millett, on some of the affiliate issues and some of the paragraphs that the court was referring to, and in particular the initial decision, paragraphs 25 through 27, where the commission in fact addressed affiliate issues when it comes to determining the geographic destination market. The commission's basic analysis is in the earlier paragraphs of the order, 18 to 22, where it relied heavily on the market behavior, and we can talk about that. But what I want to focus on now is what paragraphs 25 through 27 are doing. This is where the commission took a very careful look at the assertions by petitioners here, Husky and Phillips 66, that the affiliate would prevent acting as a discipline on potential exercise of market power by MPLX Ozark.
What is the JA reference in that?
Yes, Your Honor. I'm looking at paragraphs 25 that starts at JA 779. Through, and in particular, the following paragraph starts at JA 780. What I want to highlight is the footnote to the first of those two paragraphs, and that's footnote 61, JA 780. Here, the commission is citing to the rebuttal testimony of witness Dr. Webb, and using what he labeled as a conservative elasticity, determined that the non-affiliates would cause losses if there was an exercise of market power here. And I can point to there's a specific number. Again, I want to be careful not to discuss sealed material, but his exhibit that he was referring to is at JA 1391.
Is there a footnote to that effect?
The footnote I'm referring to is in the commission order, paragraph 25, note 61. This is the reference to Dr. Webb. And this is in support of the commission's determination that the significant minority of non-affiliate shippers would help to discipline an exercise of market power. And I just want to point out two things about what Dr. Webb says that the commission is referring to right there. He's making so I already mentioned the conservative elasticity. He also assumes in that analysis that Phillips 66 has no response, no discipline whatsoever. And he also assumes that the affiliate shippers have no discipline whatsoever. And that's an interesting point, because if we look at the next footnote, the commission cites a cross-examination of Dr. Norman, and where Dr. Norman says that, well, it's not that there would be it's not that the affiliate shipper would have no incentive, the affiliate shipper would have a reduced incentive.
It just seems to me like these two paragraphs in the footnotes you're talking about are FERC saying why trial staff was wrong. Okay, but
Would
to
agree
have
with that.
substantial evidence, they have to show what's right.
Correct.
They can't just say you're wrong.
I agree.
So where do they have substantial evidence that there's not going to be this affiliate problem, that there really will be customers with a choice in the Pawtucka market, which is their argument that they're really an apparition given their affiliate status, that there's going to be any real choices made. And the analysis that I see in 27 is really more about the switch from, it reads to me at least, from the MPLX line, I think I've been saying that wrong, but the MPLX line to the Woodpat pipeline, changing between the two lines and charges there, which seems to be potentially different from the ability, the price is actually charged then to everybody who's going to travel down these lines, and in particular, over the long term, to be able to essentially make the affiliates not relevant customers for purposes of this destination market, Pawtucka.
I think so now backing up into the commission's primary analysis. So these are paragraphs 18 through 22. And what the commission there was saying that there are alternatives. So the alternatives available are the ones that are available in Pawtucka. So we don't have to assume.
But those, they're not talking about the affiliates, right? I mean, you were right. They didn't talk about affiliates, at least as I have it, until like paragraph 25.
That's correct.
Okay, so but before that, they're saying there's customers, there are other pipelines in Pawtucka, but we don't know that there's a sufficient number of customers there from the Wood River to Pawtucka link that the people are going all the way through that are going to be able to actually exercise any kind of meaningful check on Ozark / Woodpat's ability to increase prices, exercise market power in a way that would really make this not a matter of customer choice. I mean, I think that's what they're saying when they blend the competition in, is that there really isn't going to be realistically customer choice in Pawtucka in the way that FERC found it. And so where is your evidence that customer choice will be there by a majority of shippers?
I guess I would say two things. First of all, I would refer back to the footnote that's referring to Dr. Webb's rebuttal testimony. I think he is saying that the non-affiliates alone are sufficient to discipline this market, and the commission cites that in the footnote. But backing up,
How can a minority have enough control?
And
And there's not a lot of options between Wood River and Pawtucka. There's lots of options in Pawtucka. There's not a lot between Wood River and Pawtucka.
but they don't have to go to Wood River. These shippers can't. The problem here is that available options are being ignored by the analysis suggested by my friends on the other side. That's Dakota Access, Southern Access, and the Mustang. They don't go to Wood River. Those are,
Was there not, maybe I'm wrong, correct me. I thought there was evidence in the record that those pipelines were either at or very close to capacity already.
those are, that's not I don't believe that's an issue. And I'd go back to
Wait,
the,
is that a factually accurate description of the record or not?
I am not sure. I would refer, Your Honor, to the initial.
Okay, assume, and then we can verify the record citation. Maybe they'll have it or you can provide it later. But if they are at or near capacity, then they're not a real choice, are they? Or tell me how FERC explained that they would still be a choice even if they don't have room to add stuff for.
I think that's a question of whether there are competitive alternatives available, and that's
Whether there are alternatives available. Full stop.
I
The
think
whole premise of picking Pawtucca, as you just said, is that that should be the destination market because not just because a large percentage of the oil majority is moving from Wood River, Pawtucca, but because by the way you define a destination market, that's where customers are purchasing here oil and where they have choices about purchasing oil. And so I'm testing that part about if they only had one choice of purchasing oil in Pawtucca, it wouldn't be a good destination market. And so they have to have choices. That's how FERC framed the analysis anyhow, depending very heavily on these choices. But if those choices are phantasms, they don't actually exist, then how can, and maybe just I'm wrong about the capacity, but if I'm right about capacity, how can this possibly be a relevant destination market under FERC's own test for what it takes to be a destination market?
Your Honor, here I would refer maybe to we have extensive citations at page 56 of our brief, and I can go through some of those, and it starts with the citation to witness Steck-Schulte at page 11, who talked about the highly.
Yeah, let me make sure I'm on the same page. Which JA page?
This is cited, I can tell you, his testimony is at JA 511.
Mhm.
And I can tell you where this is cited in the commission orders, footnotes 42, 55, and 60.
This is the original decision.
Yes. And he talks about the highly desirable nature of the Pawtucca hub and that there's infrastructure there for further transport. And he talks about that the significant majority of the volumes on MPLX Ozark go to Pawtucca.
So I get the significant, significant majority, you said there's a significant minority, but certainly the majority of oil is going on from Wood River to Pawtucca.
That's right.
I get the commission found that. You just mentioned a couple other things
Yeah.
this witness said. Where does FERC say those same things?
I would.
Just because FERC cites some witness doesn't mean that everything the witness says is not part of FERC's decision.
Yeah, I would cite the footnotes 42, 55, and 60.
I know, but where in FERC's decision itself?
That is.
42 says the
yeah.
majority of volumes are delivered to Wood River for transport. Okay, we said that. Okay, and then you said 46?
42, 55.
Sorry, 55?
Yeah.
Okay, sorry, I'm just hopping here.
This is in the order, right?
Right.
Yeah.
Yes. So 55 is on JA 779. So that's saying the same thing. So twice now we're saying that lots of stuff that goes into Wood River goes on to Pawtucca, but you were citing testimony for more things, but those things are not things that FERC said.
The significant majority of the volumes go to Pawtucca.
Right. That's all you're citing him for?
Right.
What's that got to do with
and-
whether there's actual real world competition in Pawtucca on these other pipelines if they're at capacity?
I think we have actual shipper behavior, and for that, I would move to the next citation to the record, which here I would cite Dr. Webb. And I'm looking at pages 49 and 51 to 56. And this is
Wait. Of the FERC decision?
of his
I
testimony.
want to know where FERC said this.
Okay,
The fact that I'm trying to, maybe I'm not being clear. The fact that a witness says it
I-
isn't enough unless FERC adopted that rationale.
Yeah.
So where did FERC say what you're about to
Sure.
say?
Notes 42, 45. And I don't want to go too fast here. I can read these into the,
No, but 42, I mean, again, they're citing to Webb, but where are they saying what you're saying Webb said?
I think the challenge here is that in my notes here, it's in red ink, meaning the citation to Webb is going to be to the sealed version of the JA, and I'm glad to provide that citation to the court.
No, but I can't.
The commission can't say some of
But
these.
no, but 42 is a footnote that says, comes after the sentence, the majority of volumes on MPLX go from Wood River to Pawtucket. If that's all they're citing Webb for, then it's not helpful to you. And if they are citing it for a additional legal proposition or factual finding, they need to make that somewhere. They can do a redacted decision, but I can't, if all that footnote, all that precedes that footnote is the same point that we've made 4 or 5 times about the movement, and that they don't contest about the majority of movement of oil from Wood River onto Pawtucket. No one contests that. And as far as anyone can tell from FERC's decision itself, that's all they're citing, that's Schulte and Webb for. And I don't know how we can then look at all these other pages and bring them in and say FERC was adopting those things if they didn't say it.
I do want to make sure I mentioned all the footnotes in it, and I take your point. I can't change the way the order is
Okay,
written.
do any of the other footnotes come with FERC making any of the substantive analysis that you're saying they're citing to?
I would say yes, Your Honor. I would push
Tell me
back.
where FERC said it.
And FERC is looking at the market, and FERC is saying that the behavior of the market participants indicate that the appropriate market includes Pawtucket. And I would, if I could stick with Webb for a sec, Dr. Webb for a second, and he discusses at length what the behavior of Phillips 66 is here, and a lot of that information I can't disclose, but it's in the sealed version that the court has, and that's at JA.
But what FERC could say in its decision is, we find the behavior of what you just said here in court of Phillips Petroleum supports our determination X. Did they say that?
I would point to paragraph 20 at JA 776.
Okay.
And that's where the commission says that the market should include Pawtucket because it has alternatives available. The commission was right about that. And in support,
Right, in the sense that the pipelines are there.
the pipelines are there and,
But what if there is no capacity?
Or not enough?
well, I think I would point to Dr. Webb's testimony that I referred to, and that indicates as a practical matter, the capacity is there. And that's
How much capacity does there have to be for switchers to exert to make a price increase on profit?
I'm not sure I know
Significant
that.
minority.
I'm not sure I know the answer to that, but again, I would cite what the commission cited here. I would refer to what the commission cited to support that proposition, and that's a footnote 61 that cited Dr. Webb's rebuttal testimony.
Well, let me put it another way. How much throughput is there now beyond Wood River? Is that confidential?
I think the number is confidential. It's a substantial majority that goes to Pawtucket from Wood River. And what the commission was saying in paragraph 25 is that a significant portion of that is.
Yeah. And is it in the record and unredacted how much capacity Capwood has? Not excess, total.
I don't have that in front of me. I would think it must be in the record.
Keystone one of the players?
I'm sorry, Your Honor.
Is Keystone one of the players that could take oil to Pawtucket?
Yes, it is.
All right, so it looks like there's what looks like a great deal of uncommitted capacity there.
And I would refer Your Honor to,
However, if let's assume there is, what do we make of Husky's point that it's not really in play unless the price of crude there is competitive, right? That the shippers are going to aren't going to take advantage of a pipeline's alternative route if they're going to be selling at the other end where the price is not as high.
And again, and I would refer to the footnote 19 of the initial order. The competitive alternatives aren't contested here. There's no question that if we limit the geographic market to Wood River, the competitors are Keystone and Platte and Capwood in addition to MPLX Ozark. But if we expand it, then that Capwood falls out and Dakota Access, Southern Access, and Mustang gets included. And that's why we see the change in H.
I'm sorry, and I won't say it out loud because it's in the sealed appendix, but just on 1096 to 1098, we have question, answer, question, answer, question, answer, question, answer, and they're all at or near capacity. I mean, right, do you have your sealed appendix in front of me? Am I right? Starting with line 15 on 1096 through line 7 on 1098, and they're going through these things and they're at or near capacity. I'm misreading it?
I don't.
Technical stuff, so if I'm misreading
Yeah,
it,
I don't.
tell me. Just seems, direct questions.
I don't think so. I think, again, I don't think the
You don't think I'm
competitive.
misreading it?
No, and I don't think the competitive alternatives are actually disputed here. And that's what the commission is saying in the footnote.
So to back up then, we're not talking about competition, but to say that we're picking Pawtucket as part of the market, not just because of the movement, because that's a place where customers are making choices. If they're not making choices, then how can FERC's decision stand with that?
Well, I think they are making choices. And again, that gets back to some
Make
of
choices if there's no capacity on the other pipelines.
where they're actually using, I think the behavior of the participants here in the market, and there's
I'm
some.
very confused. If they're at or near you're saying they're at or near capacity because everyone's already using their things, or that?
That could be. I would refer
We don't know though.
I don't think that was an issue here. The issue here is that's the second step, whether the competitive alternatives are good and available. I don't think that comes into play here.
Okay, how does FERC define what is a destination market? How it looks for what a destination market?
It looks for where shippers can, where the shippers can ship. The commission discussed that
It can't be just where shippers can ship.
at paragraph 19. The destination market, this is JA 775, where the shipper may rationally look for transportation and where the shipper's supply downstream needs and where alternatives may be available if the pipeline attempts to exercise market power. And the commission explained what the analysis here.
You can't rationally look for transportation service if everybody else is already full.
I think that's
except for this pipeline that has, for their arguments about the affiliate relationships and ability to exercise market power, their arguments.
I think that's a question of whether the alternatives are available, and that's the next step. And I think what the commission is saying here is that these.
I mean, in the next page, the commission also considers whether the appropriate, this is the same paragraph on top of 776, the commission in identifying the destination market, not the competition step one. The commission also considers whether the appropriate geographic market definition should be expanded based on where shippers may look for alternatives in the event of a price increase. So that's part of identifying the destination market, correct? That's what FERC said.
Yes.
Okay. And so that's why I'm asking, and clearly it's in the record, testimony about capacities on other pipelines. And so if one were to assume that the record were to show that all those other pipelines at Pawtucket are already at or near capacity, how would their existence support FERC's determination that Pawtucket is a place where shippers may look for alternatives in the event of a price increase. That's where I'm hung up. That's what I'm not understanding.
And again, and now I'll get back to Dr. Webb's testimony. I think he explains what, for example, what Phillips 66 could do. And I want to be careful not to use any of the information that's sealed. But this is at,
Okay, but we don't have FERC anywhere adopting that.
but I can show where FERC cited Dr. Webb.
For a different point.
That
That was just for the movement point from Wood River to Pawtucket.
I think they cited
You're saying that-
Dr.
Even though the only sentence in the opinion says, before the footnote says, this is to show movement from Wood River to Pawtucket, a majority or most, I think they use different words, of oil moves from Wood River to Pawtucket. Footnote, and they cite the two experts. And you're saying when they did that, they were also endorsing everything that Webb said on the cited pages.
I think
That's how we're supposed to interpret that without them having said that.
sorry, Your Honor. I think what the conclusion here is that the behavior of the shippers demonstrates that this is one market. And they cited these pages, and I can show you the footnotes where Dr. Webb was cited for these
One
propositions.
market because they're moving back and forth.
And they have alternatives. Yes, that's what Dr. Webb,
Okay, which pages?
yeah.
You want to look for Dr. Webb?
Yeah, and here I'm referring to pages 49 and 51 to 56 at JA 1247 and 1249 to 1254.
Okay. Sorry, I've had a lot of questions.
And I'm sorry, Your Honor.
No, I've asked a lot of questions, and my colleagues have some as well. Do you have any questions?
No. Did you say at some point that FERC said the competitive alternatives are uncontested? Am I hearing you correct? And if so, where'd they say that?
In footnote 19, the parties agree on what the competitive alternatives would be. If the geographic market, and JA 770, if the geographic market's confined to Wood River, the competitive alternatives would be Keystone, Platte, Capwood. And if it's expanded, the competitive alternatives here pull in Dakota Access, Southern Access, and Mustang. And Capwood would fall out
I thought
because
the Dakota Access, I thought that was contested. Southern Access, Mustang. Is there some finding somewhere where FERC says the parties do not contest the?
yeah, I'm referring to footnote 19, JA 770.
Okay.
No further questions?
No.
All right.
See, I'm over time. Is there?
So the statement that that the shipper could simply, and that's the word used, I believe, simply divert barrels to Pawtucket through another carrier is made without reference again to the availability of capacity, correct? That's at the bottom of 1249.
That may be true.
I don't understand. That's what I'm not understanding. How could there be agreement that competitive alternatives exist without the parties thinking about capacity when they made such an agreement? So I'm not sure how we're bringing together what we're talking about in the record. Have the parties agreed that did FERC say the parties agreed that there were competitive alternatives available, which to me means capacity would be available. You can't have a competitive alternative if they don't have the capacity, at least not in my mind. That doesn't make sense. Is there such a finding here that there's no disagreement on the point that I asked and Judge Ginsburg had just asked? In other words, was there some disagreement over capacity somewhere?
Not that I'm aware of. I think the way the commission's analysis here is to look at these markets and look at the market behavior.
Right.
And I can go through the colloquy I had with Judge Millett about some of that behavior of Phillips 66. And we can also talk about what Huskies, there's some testimony that we haven't gone to that would talk about what Huskies options are in Patoka that don't go through Wood River. And that testimony, and I can cite that as well. That is the testimony of witness Chan at pages 2 and 4, JA 267 and 269.
So that's not sealed.
No.
Where do they discuss capacity?
And that's the testimony there is that all of Husky's volumes are shipped to Patoka and then to Lima. And that the testimony is that Husky could purchase oil at Patoka or secure transportation on Dakota Access, Southern Access, or Mustang or Keystone Platte. And then
Testimony made with any reference to capacity or whether Husky had arrangements?
I don't believe so, not there.
Any other questions?
No.
Great. Thank you very much.
Thank you, Your Honor.
Over time. You have intervener. Ms. Kohlhausen, I said that correctly?
Good morning, Your Honors. May it please the court, I'm Elizabeth Kohlhausen on behalf of the intervener, MPLX Ozark Pipeline. I want to start today by going back to a discussion that Judge Ginsburg had about whether the commission had ever defined the market in this way. And I would point you to the case Enterprise Products Company. It's often referred to as Seaway 1. It's at 146 FERC 61115, and it's referenced in footnote 35 of the commission's ID, or the commission's decision. This is the case that underlied the court's decision in Mobile before this court, and I'm just reading from this decision. It was a contested market, and in that market, it said trial staff using actual operational data from the pipeline traced the crude oil that Pegasus received backwards to its injection point to identify all potential alternatives to Pegasus. That's paragraph 35 of this order. It's cited in footnote 41 of the commission's decision. So the commission has, in fact, undertaken exactly the same analysis to define the market. In this case, it undertook it previously in the Pegasus decision. And finally, I don't have much time, but I would like to discuss the fact that the issue that was presented to the commission on briefs and here regards the determination of the geographic destination market. There's been a lot of discussion about whether alternatives are good alternatives, whether they're used. There's not a lot of discussion about that in the court's decision. In the commission's decision, frankly, because it wasn't a topic that was contested, as footnote 19 shows. I understand the question about how is an alternative a good alternative if it doesn't have any capacity. That's been discussed extensively by the commission before in other cases. It wasn't discussed here, and unfortunately, I don't have the site here. But the idea is that someone could buy the crude after it's shipped on one of those alternatives. So it doesn't have to.
Possible that the current carriers have already provisional rights on other carriers?
Yes, that's also the case. If you look at figures 2 and 3 in our brief, the intervener's brief, and I'll give you the joint appendix site. These show the significant, it's JA 1251 for figure 3 and JA 1252 for figure 2. These are highly confidential exhibits, but one shows the movements of the petitioner itself right now in the markets. And which of the pipelines, this is figure 3, which of the pipelines it already uses. So this is evidence that regardless, I think this is why this wasn't contested, because there's actual use of these by petitioners right now. And the commission could see this, as could everyone else.
But it needs to have, what needs to be shown is that at least the majority, if not all non-affiliate shippers, will have access to these other pipelines if they have to take all their oil off of MPLX/Woodpat due to hypothesized super competitive increase in prices. Not that in the past they've been doing it when Woodpat or
Right.
when there's already just a filed rate in place, so then they wouldn't be looking for capacity or using capacity as a protective measure against that filed rate. Well, the question is whether it's a protection against opening MPLX up to the ability to use market rates, and then theoretically, and I'm not accusing anybody of anything, but theoretically, to imposing super competitive prices. We don't, is that here? And I take your point. I mean, FERC says they appear to agree. And so it's not, I'm not sure what it means when parties appear to agree to something. It seems to me they appear to agree that these are options they have right now. And I'm asking about a different world. They have capacity right now when there's no reason for them to jump off MPLX.
I guess I would respond in 2 ways to your question. First, the analyses that the commission conducted to support its decision that these markets were competitive, it considers these alternatives. And I think that was, although you may not see it exactly in footnote 19, everyone included the same competitive alternative in those HHI analyses. This was not an issue. You didn't have petitioners arguing there's no capacity, so this one should be excluded. It just wasn't before the commission. Also, I do think it's important that it is not, the way I think about it is not that it has to be an exact, that shipper can move, but it could buy the oil in Patoka that another shipper moves down those lines. And I think if, again, it's not in the decision.
I thought petitioners here were shipping oil.
Yeah.
They're not just purchasers.
That's correct. If you look at the statement that Mr. Chan made, he has testified on behalf of the petitioners.
Put me back to that page again, please. Sorry.
Yes, Your Honor. It's in footnote 43. I don't have the JA right in front of me for it. Mr. Chan was asked in his testimony, what are your alternatives? They asked him. He said, buying crude oil in Patoka, which demonstrates the point I was making.
Okay.
Shipping crude oil to Patoka, meaning he recognizes there's other pipelines, he listed them, or shipping to Wood River on a different pipeline than Ozark, and then shipping to Patoka.
And that question was asked, what are your options if super competitive prices imposed by MPLX/Woodpack?
I believe the exact wording was, if you don't use the applicant pipeline, what would be your alternatives? And they listed buying in Patoka, shipping in Patoka, and shipping to Wood River and over.
And that was petitioner's witness.
That's correct. And so I think, I agree, it is hard to point in here to some of these questions you're raising, but I think that's because that wasn't what was before the commission. I believe I'm over my time.
Thank you very much.
Thank you.
Okay, Mr. Wagner, we'll give you 3 minutes.
Thank you.
Wagner,
Yes.
I'd like you to look at page JA 1254, please.
Ready to have it?
The answer at line 9, part of which is confidential, goes to one of the points we've been discussing. Is that statement accurate? One of your clients?
This is a statement by Dr. Webb. This is the pipeline's witness, his testimony on JA 1254.
Right.
Which,
It's Pipeline's witness.
Oh, I'm sorry.
Is it accurate?
Is it accurate? No. Outside of the confidential material, it says thereby defeating the coordinated price increase. And that is not accurate. That's not proven. And that's what's needed to be
Well,
proven.
I'm asking about the phrase that is confidential. Is it accurate?
Regarding rights?
Yeah.
I believe it does have those long-term contracts, yes.
Thank you.
One thing I'd like to very quickly go back to in respondents' discussion is the citation to Dr. Webb's testimony at paragraph 25, note 61 of the commission's decision. On page 55 of FERC's brief, they expressly disavow relying on that. It states that they looked at commercial realities, not Dr. Webb's quantitative analysis. So to the extent that they're relying on that to sort of backfill missing substantial evidence, that they've expressly disavowed relying.
are they missing substantial evidence? Did you raise this capacity issue? I mean, it's a very confusing record.
It's not so much the capacity issue.
So you didn't argue that there's no real choices in Pawtucket because of capacity constraints, or at least for a lot of the shippers, maybe not one, but maybe for a lot of the shippers, non-affiliate shippers, there's capacity constraints. You haven't raised that?
We raised that there are not delivered price, that the delivered prices are such that you would not shift to any option at Pawtucket.
Not because of lack of capacity, but because of the destination market price.
That's correct. So that must be tested. You have to look at the delivered price. What FERC has said is, we assume that these are currently used. Here's a map showing flows. And because these are currently used, they're assuming that the price would be such that shippers, enough shippers to move the needle, would respond to a price increase by shifting. That's the fact that's missing. If you don't show that someone would shift to another location using hard evidence, using actual delivered prices, then it doesn't do you any good to say that under some other set of conditions, people use these pipelines. Is there incremental discipline? The answer is no, and there's nothing in this decision that says that there is.
Do you disagree with footnote 19 in FERC's original decision, page JA 771, about the existence of competitive alternatives?
Oh, the footnote?
19.
Kind of a nuanced answer. The ALJ required the parties to provide HHI analyses under various sets of assumptions. And if the destination market is Wood River, and the capacity of X pipeline is this. What's the HHI and what results? And there's a table in the joint appendix showing that. We're not contesting that if the destination market includes Patoka, those are the pipelines that go to Patoka.
That you have alternatives there.
It's difficult to agree with that. We would not shift at all to Patoka. So
I don't know what you mean.
no alternative at Patoka is competitively priced such that we would shift and actually discipline the market, discipline the Ozark pipeline. So that means that no alternative at Patoka, nothing should be looked at. FERC makes a really
Based on price, not capacity.
based on price. And FERC makes a really significant error in that regard in all of its, going back to that Seaway decision where they say all used alternatives are necessarily competitive. That's, again, that's the cellophane fallacy. And they've sort of forced the debate into what's the market then? If we're going to assume that everybody in a market is competitive, that puts the debate there.
Any other questions?
No.
Thank you very much.
Thank you.
Case is submitted. Court will be in a short recess.
It sounds like it was a very. Bill. Yeah. Yeah, I have to go to help first. Okay, so check it out. Which is, I'll pick up penalized. By the time I get a close to yeah, I get a camera. It goes like fun camera. Piece of place I didn't have. No one. Surprised. Other than. No, but it's still.
was hoping you'd say that. But I'm constant care when it comes down. Yeah, it's like. So much. No, but. Like I said. Yeah. Other than a couple of. Very good, very good name. I have two ways.
This honorable court is again in session. Be seated, please. Case number 23-7112, Bainbridge Fund Limited Appellant versus Republic of Argentina. Mr. Costantini for the appellant, Mr. Bukudzi for the appellee.
May it please the court. First of all, good morning to you all. My name is Tony Costantini. I am from the Duane Morris firm, and I'm representing appellant Bainbridge Fund, which has a $95 million judgment against the Republic of Argentina issued in the Southern District of New York, and we've appropriately registered here in the District of Columbia, and we are now seeking to attach a property on All Street that belongs to the Republic of Argentina in order to satisfy part of their judgment. The case concerns one statute, but in two different ways. It's 28 U.S. Code 1610A, and specifically the commercial activity in the United States part of that code. The first question is whether the property was used for commercial activity, and we'll present why we think it was and what we think are flaws in the district court's judgment otherwise. The second question is whether we need to show that at all in light of the Republic of Argentina's consent under the Foreign Sovereign Immunities Act to any post-judgment relief. With respect to the first question, I think the facts are pretty clear from the record, and they're basically uncontested. The property was once used as a residence for people from Argentina, basically the Defense Department, but that use was 35 years ago. And at current time, it has no diplomatic use unless you count that there are some records stored in the basement. And I think significantly,
Well, no diplomatic use does it, commercial use?
it does not. I am going to get into why we think there is commercial use. But you're right as to that, Your Honor. I just wanted to mention, because I think it's important in the overall analysis, that the State Department removed the property from its diplomatic roles over 20 years ago. We have, since they stopped using it for a diplomatic purpose, they used it for tenants. They rented it out. They have twice tried to sell the property, complete with real estate agents and bids, et cetera. And they have twice removed the property from sale when someone like us challenged the ownership of the property through an attachment. And in fact, another panel of this court has said that that should be considered in any analysis because that panel suggested that it may have been manipulative. As I said, it has been removed from the State Department's a list of diplomatic. Since then, the District of Columbia has reclassified the property as residential. It has imposed real estate taxes, which the Republic has paid for the last 20 years. And we're talking about hundreds of thousands of dollars without any protest, at least any protest that we know of that's in the record.
Congress has distinguished commercial property from other property held by a foreign nation. And you're telling us that private parties should be able to alter the balance that the Congress struck by waiving the protection.
I think you're referring to my second argument, which I haven't gotten
Well,
into.
so far I've heard only facts.
Well,
So I want to hear, you've got 5.5 minutes. I think we ought to get some law.
let me finish, if you were, in first of all, in the decision below, the court made the presumption that it was our burden to show commercial activity. That's contrary to precedent within this circuit. We have cited the EIG case, the Rodriguez case, but there are literally a number of other cases where the circuit has said the burden is on the sovereign. So the court did not place, the sovereign has to show immunity. So the court below did not require Argentina to do that, and we think that makes a difference. And in the analysis of commercial activity, the court below did not consider the fact that the property was removed from the diplomatic list by the State Department, that the District of Columbia had charged real estate taxes classified as residential, and that has been paid. I think all of those factors have to be considered under what this court has said is a holistic approach, and I think it's the In re Tig litigation. And we say, okay, the diplomatic use was long ago. The commercial use was more recent, not aberrational if they've tried to sell the property twice. The possible manipulation should be considered, as should all the factors that have occurred over the last 20 years with respect to the loss of diplomatic status, the imposition of taxes, and the payment of those taxes. And taking it all together, we added up to commercial activity, and that is the result that we urge on the court. If the court applies what it has said is the proper standard on burden of proof in this type of case, and if it considers all the issues that the district court did not consider. If anyone has any questions about that, this aspect, I can do this now, answer questions now, before I move on to the other aspect, which I think is what Judge Ginsburg was asking about before. I will then move right into the other aspect. What I would like to do is do it in, first of all, turn your general attention to page 129 in the joint appendix. That has the most important parts of the relevant contract between Argentina and the bondholders. It says that, first of all, that the Republic agrees that a final non-appealable judgment shall be conclusive and binding upon it and may be enforced basically in any court. I don't think you could be more broad than that in terms of saying that we in this agreement are agreeing that whether or not there is commercial activity, you could enforce it in a retaining court. Now, right after that, it says the Republic has agreed not to claim and has waived immunity to the full extent permitted by the laws. The appellate courts that have dealt with that issue have looked at it very carefully. They said laws of such jurisdiction, that would include the Foreign Sovereign Immunities Act, and the Foreign Sovereign Immunities Act says a commercial activity. So therefore, our view of this clause is that commercial activity is still required. As was said by the Second Circuit, they regard this clause as coextensive with the Sovereign Immunities Act. Not so with respect to the next clause, which is where we draw our attention. The next clause says that the Republic consents generally for the purposes of the Foreign Sovereign Immunities Act to any post-judgment relief. In our view, that language is completely and totally inconsistent with the Foreign Sovereign Immunities Act's requirement of commercial activity. How could you have any post-judgment relief if the commercial activity clause stands in the way? I think this is a deliberate choice by the Republic to create, at the very least, a misimpression upon investors. When you go beyond that, there is an exception in small Roman numerals for various assets of the Republic. So I think that further shows that the Republic understood that it was surrendering or consenting to this. So we have, we think, a clear conflict between the language of the specimen note and the statute. The court below resolved that conflict by simply saying, and he may be right, although I think he's wrong, that you can't, no matter how much you broaden the waiver, which I think recognized that the waiver was being broadened, it cannot overcome the Foreign Sovereign Immunities Act. Our answer to that is why not? This contract interpretation is regarded is under New York law. New York law, and we've cited some New York Court of Appeals cases, and there are more. That it basically says that that a party to a contract can give up any statutory or constitutional rights that he or she has, as long as the surrender does not violate public policy. And we don't see any violation of public policy here. And we think in this case, New York law should overcome the commercial activity of the requirement of the Foreign Sovereign Immunities Act. especially when you consider how the language is put together. It clearly, and the Second Circuit has reviewed this.
Let me interrupt you. Unless my colleagues have questions, you're out of time, but we'll give you some time in reply.
Well, I'm almost done.
All right, please sit down. And you
Okay.
can go on reply.
I'm sorry. It basically, I was just going to cite you to a few Second Circuit cases that
Your
are,
time is up.
yeah.
Please sit down.
Oh, I'm sorry.
Yeah.
I thought you, now I understand, unless your colleagues have questions, please sit down. Yes. I guess they do not have questions.
No.
Thank you. And I apologize again, Your Honor.
Mr. Bokucci.
Thank you, Your Honor, and may it please the court. Carmine Bocuzzi from Cleary Gottlieb for the appellee, the Republic of Argentina. The district court's denial of plaintiff's motion for an attachment of the Argentine property at 2136 R Street Northwest, what we refer to as the Chancery Annex, was correct and should be affirmed. To start with appellant's second point, whether the scope of the waiver means that this court need not even consider the question of whether the property was used for a commercial activity, I want to just start with the language of the statute. 28 USC section 1610 is clear on its face. You start with A, the property in the United States of a foreign state used for a commercial activity in the United States shall not be immune from attachment and aid of execution if. And then the first if, A1, is the foreign state has waived its immunity from attachment or execution. So in other words, the universe that we're talking about and that we're limited to by the statute is the universe of property of a foreign state used for a commercial activity in the United States. What the waiver does is give a party that is signed onto a contract with such a waiver the ability to go after such property. Without a waiver, then that party would be confined to an even narrower universe. So for example, A2, if you have no waiver, then the plaintiff would be limited to property that is or was used for the commercial activity upon which the claim is based. So in this situation, we're talking about a bond and an issuance of a bond. I think pretty much if we had no waiver here and his judgment was based on that conduct, we would be talking about the null set. But as it were, the waiver opens up the broader, potentially broader world of property used for a commercial activity. The language of the waiver itself, all the Republic does in the language that he relies on is consents for purposes of the Foreign Sovereign Immunity Act to its waiver. And so, of course, that means if we're consenting for purposes of the Foreign Sovereign Immunities Act, there is nothing in this act that authorizes the attachment of diplomatic, commercial property or property that's not being used for a commercial activity. The only area in which it's potentially broader to something called, again, commercial property is in the context of a foreign state instrumentality, which of course the Republic is not. So everything ties together, the statute, the language in the waiver, and we're stuck, just as every other court that's dealt with this, and the Second Circuit has been dealing for years with this exact waiver language and always has to train the analysis on, was the property being used for commercial activity in the United States? And as to that question, I think the district court got it exactly right. It applied this court's articulation of the relevant standard from the TIG case involving this same property and another plaintiff. They're a plaintiff seeking to enforce a judgment based on an arbitration award. And there, this court said, you look at the totality of the circumstances surrounding the party, the property, to determine whether in the court's judgment it's being used for a commercial activity. Importantly, you don't artificially narrow the point of examination. And so here, if we look at it, we're talking about a property that was bought by the Argentine Republic in 1946. It was used to house the military representatives to the Inter-American Defense Board. That is a cooperative, multi-state organization that's meant to deal with military challenges facing North and South and Central America. And Argentina was a founding member of that diplomatic organization. And so we're talking about a building that for 70 years has been there diplomatically and against this, and was on the diplomatic rolls until 2004. And against this, the commercial activity that the plaintiffs point to is the fact that it was listed for sale twice over a period of 20 years, excuse me. And then also there was some leasing activity when this property was on the diplomatic rolls for a short period in the late 80s and a little bit in the 90s. That, I think the district court got exactly right in weighing all the factors and saying clearly.
In all of the recent years, over the past couple of decades, it's not about diplomatic activity. There's been absolutely none. It's been listed for sale, bids have been taken, negotiations have been had, and there's some garbage stored in the basement maybe, but it's certainly not a diplomatic unit. And so the best I can notice about this property is that it's on commercial markets, and bids have been taken, negotiations have been had. Why not?
Again,
You can't talk about what happened in the 80s. That's not what this property is about. It's a rundown piece of whatever, as described in the record, and it's been put up for sale several times and bids taken. Most recently, it is not a diplomatic unit. It's not recognized as such. They pay taxes on it.
It is there's evidence in the record that the diplomatic mission considers it part of the diplomatic mission. It's under the aegis of the Ministry of Foreign Affairs of Argentina. Only people from that ministry have access to the building. There are some diplomatic files there, but importantly,
They own the commercial property. That's true. So they're the only ones who have the keys. I don't know what that proves.
But I think the important.
They originally owned it and they originally used it as if it were diplomatic property that's not being used that way anymore.
But I think the toggle, Your Honor, is not, if it's not diplomatic, then it's quote commercial.
Oh, I totally agree with that.
So the question.
One doesn't prove the other. I absolutely agree.
And so the question is.
I'm looking at how it is being used. And the only uses I see, apart from some garbage stored in the basement, is that bids are up and negotiations with brokers are ongoing, and that's what we see happening with this property now.
But again, if we look at it, so it was listed once in 2004, that yielded no bids and it lapsed. And so nothing happened. There was actually no.
So they listed it again.
And then 14 years later, it was listed again. There was no accepted offer. And so if we're just training, if we look at that and those two instances.
Well, a continuous interest in trying to get rid of this property.
I'm not, there's no, and Judge Bates found this, and I think it was not clearly erroneous. There is no showing, and plaintiffs concede that it was not a continuous interest in selling the property or continued attempts to sell the property. In fact, you had these two instances. Don't forget, Argentina has been going through the beginning of this time period, the worst financial collapse in its history, in its modern history. And then later on, it had problems throughout. So it didn't have the money to fix the building, which is another possibility. The building could be restored by them and put back into diplomatic use. And so at 2 points, there was a consideration for a sale that never turned into anything. And I think here, the totality of the factors test, if it means something, it doesn't mean you just look at those 2 moments of time, because there is no evidence that in between that there were any interest or intent or plans to sell or use of this property in the market at all. So if you look at those 2 moments of time against this backdrop, and again, the fact that this is, it wasn't the Argentine steakhouse, it was a diplomatic residence for all these decades. And so it's not something that's been moving in and out of commercial use. You have these 2 attempts, they didn't go anywhere, and then you have a property that's not being used for anything. And used for a commercial activity has been held consistently across the circuits to be a real requirement. It's not just property that's sitting around, property that's not being used. It has to be property that's used, again, in the totality of the circumstances for commercial use. So for example, the Fifth Circuit case, the AVCAP case involving the Congo, there they looked at royalty payments the Congo was receiving over a period of 24 years. And the Fifth Circuit in that case, reversing the lower court, said, well, for 11 of those 24 years, you, the Congo, were using that money in the old-fashioned sense, commercial sense, to settle claims against the Congo, commercial obligations of the Congo. Therefore, given 11 years of actual economic commercial activity over a 24-year period, we think use for a commercial activity is satisfied. You don't have any of that here in terms of a lengthy, continuous use of this property. It just hasn't been used. It's fallen into disuse. And then you have these 2 moments in time where it was listed and there was no actual sale that happened. I also think it's important to think about the sort of policy ramifications of what my adversary is saying. This town is obviously filled with embassies, diplomatic properties, and the rest. That's what they generally exist to be. And if we're going to say at the moment any of those are being sold, say by a debtor nation, that a creditor can swoop in and disrupt that sale, particularly if the sale involves another sovereign, et cetera, I think that is not what is contemplated by the FSAA, and it's very strict requirement that something actually be used for a commercial activity, and then also 1602's reference to actual commercial property. So unless your honors have further questions,
All right, thank you.
thank you.
Why don't you take 1 minute?
Thank you, Your Honor. I'll be very, very brief. My adversary said that every court that has considered this issue has sustained the continued commercial activity use. Every court that has considered this issue has considered the waiver clause. And the way they have considered the waiver clause is whether the waiver clause is inconsistent with the Foreign Sovereign Immunities Act, and it decided that it was not. This is different. This is the consent clause, which is inconsistent and which no court has ever considered the implications of. And that's the only thing I wanted to point out in rebuttal.
All right, thank you.
Thank you very much, Your Honor.
Case number 23-5074. Mohammed Jibril, individually and on behalf of their minor children, AJ, and OJ et al., appellants, versus Alejandro and Mayorkas in his official capacity as Secretary of the Department of Homeland Security et al. Ms. Jump for the appellants, Mr. Waldman for the appellants.
Ms. Young?
Thank you, thank you, Your Honors. May it please the court, I'm Christina Jump, and along with my colleague Chelsea Glover, I am here once more on behalf of the 7 members of the Jibril family. This court held that ex parte in-camera resolution of dispositive issues should be avoided whenever possible. That instruction was issued by this court in Ellsberg v. Mitchell and remains true today. In this case, resolution at the Rule 12 stage based solely on ex parte in-camera submissions of a factual challenge, in particular, most certainly could have been avoided, but the district court failed to do so, despite its express reservations and recognition that the government has not entirely explained why national security concerns exist in this particular case, particularly with respect to the minor plaintiffs. We represent that that was error and ask that this court reverse that holding and remand back to the district court.
What did the department say about the minor plaintiff?
I'm sorry?
What did the department say in its letter about the minor plaintiff?
The government, what does the government say? Your Honor, honestly, I don't know. And that's part of the problem. There's not much that we can say, that we can see, that has been submitted this time that is not in camera. I will say that we are aware that minor OJ, one of the youngest of the Jibril family members, originally received a separate and distinctly different letter in response to the DHS trip complaint on behalf of him, then did the other 5 members of the Jibril family that did receive letters as well. So 5 received the more standard, can neither confirm nor deny letter, and OJ received a different one with different wording that also did not identify anything, but did diverge from the one that the other 5 received, and the seventh member of the family never received a letter from DHS TRIP. Based on
You've
that,
seen the letter concerning the minor, correct?
I've seen the letter that was issued by DHS TRIP, yes.
Okay, and you still haven't told me what it says.
Oh, I'm sorry, Your Honor. The letter issued by DHS TRIP, the language that differs as to minor OJ, is that it does not contain the language that DHS TRIP can neither confirm nor deny any information about which you, which may be within the federal watch list, or reveal any law enforcement sensitive information. That is the language that was in the other five, was not in his. Instead, minor OJ's letter contains the information, it contains the language that the U.S. government has completed our review of your case. Your experience was most likely caused by a misidentification against a government record or by random selection. We regret any inconvenience you may have experienced and, where appropriate, have made updates to our records that may assist in avoiding future incident of misidentification.
Thank you.
Based on the fact that there is at least that distinction and the motion to dismiss at the district court level this round, as well as the district court's holding, or the district court's decision, its order in this case, do not address that distinction, even following the hypothetical presented in the district court's opinion, which is all I can do. Following that hypothetical, even under that, the hypothetical that if, hypothetically, one member of the family, say the father, were on the watch list, and other family members traveling with him then experienced the same issues, and then he were removed from the watch list, then hypothetically, they would not have any future problems. That does not explain the distinction between the letters that were received by the individuals. There were other minors, so the minor status does not explain that either. And it does not explain why the seventh member of the Jibril family did not get a letter from DHS TRIP at any point. The district court opinion also fails to address, as does the motion for summary judgment, the fact that, as this court previously recognized, the Jibrils have an interest in religious travel and traveling internationally to Saudi Arabia for their sincerely held, religious beliefs. And the district court's decision does not address the facial challenge that we bring to the DHS TRIP redress process through the regulations at 49 CFR 1560.205. That was not addressed by the district court. The plaintiffs remain subject to DHS TRIP, whether they're on the selectee list or not. Anytime that they travel, DHS TRIP process applies to all travelers, not just those on the selectee list. As my colleague across the aisle made clear last time that we were here in 2021, that multiple individuals not on the selectee list may receive the Quad S designation and additional security screening, and their only redress as well is a DHS TRIP process. So the Jibrils remain subject to it, much like in the case of In-Read Navy chaplaincy. They're still subject to the same processes, and it is still relevant then to
What
their.
is your proposed redress?
What we, at this stage, Your Honor, what we request is remand, first of all, so that we can finally file that amended complaint, and also that we may seek, which we have not had the opportunity yet to file, despite having requested at the district court this time, with edits that will reflect what we believe, or at least suspect, to be the factual challenge presented at this time. And that we also would, for redress, would like to have either an unclassified summary presented to the Jibrils, which the government does in the context of no-fly situations. It could do here, or the district court can provide the Jibrils with some information to allow them a meaningful opportunity in a meaningful way to challenge whatever was presented to them that would be redacted, could be presented for attorney's eyes only. Courts have many avenues at their disposal other than simply making it all in camera. We do, again, we have the facial challenge to the DHS TRIP procedures and what we believe to be the lack of due process, of constitutional due process contained within those, and this case is a prime example of why. And we would like the opportunity to litigate that at the district court below. While there may be some limitations on what we can see, there may be some
Well, that's what I'm
limitations.
trying to figure out. There are some limitations. There's sovereign immunity concerns with respect to whomever it is you're suing, at least the way the case sets up now. Are you talking about damages and based on what? What theory?
I'm talking about two
I'm
things.
trying to understand what it is
Yes, Your Honor.
you're proposing.
I'm talking about two things, Your Honor. First, that we would like to either have the opportunity for jurisdictional discovery, which we asked for in our briefing, in order to determine any individual agents who may be liable for the past harm or past damages that we can name individually. We just don't have that information yet, but did add in
You
the.
ever ask for that?
We added in, we haven't had an opportunity to request it. We did put in the proposed amended complaint, a request for nominal damages as relief. And we did say in our briefing here to this court that we would, and to the district court in footnotes in our response, that we did request the opportunity to amend or to finalize the proposed amended complaint after having an opportunity to investigate further based on the factual challenge and our limitations of trying to go at it mostly blindly in order to address it. We may not be able to do that, but we want the opportunity. And
What do you perceive to be your basis for standing at this point as best you understand the case?
As I understand the case, Your Honor, first of all, we would like to amend to add nominal damages again as to individual agents in their individual capacity to the extent that we are able to identify those reasonably or be allowed to have jurisdictional discovery to find that information.
What, retrospective or prospective relief?
That part would be retrospective, and then prospectively, because the Jibrils all remain subject to the DHS trip process for future travel, and they have shown, as this court previously recognized, that they will travel in the future, are reasonably likely to travel in the future for both family and religious needs, that they are still subject to that. So we are seeking, in that sense, a declaratory relief regarding the constitutionality that we believe is deficient of the DHS trip redress process as it currently exists.
Taking the district court's hypothetical as using it as a question. If things are as the district court, if things are as the district court's hypothetical raised, what standing would you have based on what?
Your Honor, we believe that that's.
For going forward.
Yes, for going forward, Your Honor, we believe that we do still have standing in that context, in that using the parallel of the voluntary cessation standard and the language that was addressed in the Kovacs case, which is cited, as well as True the Vote versus IRS, which is cited in our briefing, that the defendant's own choice to state, trust us, this won't happen again, is not sufficient. That is not a sufficient reason and belief and understanding to say there is no chance of this happening again regarding a procedure that every traveler is subject to using should any traveler have a complaint going forward. So we do not believe, we don't agree with the district court's holding to the extent that we can see the reasoning for it.
No matter whether any of the plaintiffs have ever been on a list?
I believe it matters. I don't believe that it's purely dispositive. I believe that it is one indication. But again, as I indicated, they are also all still subject to the DHS trip process for the.
I mean, that's a high mountain to climb, isn't it, in light of the case law, in light of the statute, with respect to what the government is allowed to do?
The government has a lot of.
We're all subject to that.
We are, and I believe that the Jibrils have shown, based on how they've been treated in the past and based on their demonstrated likelihood of repeat travel in the future, and the fact that neither the district court holding or from what I can see, the government's submitted factual challenge at the 12v1 stage, none of that addresses the distinctions that do exist, for example, with the letter to young OJ, and as well as the failure to even issue a letter to the seventh Jibril family member. Those have not been identified. Those have not been fleshed out. So from what I see, I don't see a resolution to all of the questions. They may still be subject. And again, it is at the government's discretion to put them back on at any time. And if there is information that is so compelling and so dispositive that it could have prevented this lawsuit 5 years ago, at the very least, the Jibril should be able to see an unclassified summary of that information. It may be that we can't get past that. It may be that that kills our facial challenge, but we should have the opportunity, and they deserve the right to a day in court to litigate that fully and brief it
Well,
fully.
the district court in the hypothetical suggested that some of what you're raising now may depend upon whether any of the plaintiffs were on a list at the time the complaint was filed.
I did see that it suggested that.
That changes the analysis from standing, that changes the analysis that you want to raise about mootness to one about standing.
Your Honor, I do believe, again, they did experience, all 7 of them experienced this treatment, regardless of however many may or may not have been on the watch list at that time or at the time of filing the complaint. All 7 of them are still subject to DHS TRIP as their only remedy, and all 7 of them have a demonstrated likelihood of traveling again in the future and therefore potentially being subject to this harm. I don't see anything from what I can see, and I recognize my limitations here. I don't see anything that addresses that as to all 7 family members going forward, and quite frankly, neither did the district court, as it recognized that the government had not shown in this particular case, and particularly as to the minor plaintiffs, that the national security justification rises to the level of the extraordinary circumstances and the closer inspection necessary to justify purely in-camera ex parte presentation, particularly of a factual challenge, and at the 12B1 stage, when all factual inferences should be resolved in favor of the plaintiffs. Unless there are any other questions at this time, I will sit down and allow my colleague from across the aisle to speak and hopefully be back briefly for rebuttal.
Thank you. Thank you.
Thank you.
Mr. Waldman, before you begin,
We can, unless you want, we can go to close. You want to do, because everything. What he wants. We can do. Question him. Because I definitely.
all right, Mr. Waldman, come on up to the podium. Do you intend in your argument to use any information for which we need a closed session?
Not in this public session, Your Honor, no.
Yeah.
Go ahead.
Would you like me to proceed, Your Honor?
Yes.
Thank you. Good morning, Joshua Waldman from the Department of Justice for the appellees. The district court correctly held on the basis of the government's ex parte declaration that it lacked Article 3 jurisdiction over plaintiff's claims. The district court may properly consider matters outside of the pleading in resolving a motion to dismiss for lack of jurisdiction. And this court has held that it may resolve a case on the basis of an ex parte evidence where, as here, relevant privilege is properly invoked, there is a compelling national security concern, and the government has disclosed as much as possible without compromising the privilege. The district court did not abuse its discretion in denying a motion to amend the complaint because the plaintiffs did not identify any basis for waiving sovereign immunity that would permit them to add a claim for monetary damages. To begin with, a return to the jurisdictional point, based on the ex parte declaration, the district court held that there was, quote, no conceivable way that the plaintiffs could demonstrate that they have standing or Article 3 jurisdiction, even with a full opportunity for adversarial testing of the government's position. We think that that should be conclusive of the Article 3 jurisdictional question in this case. And if the court has any questions about the public record, I'd be happy to.
Nothing on the public. I have no questions on the public. Right.
We do have questions, but we need to close.
Sure,
Session.
okay.
Everybody has to leave the court.
Mr. Sislak, can you take care of that?
Stand, please. All attorneys, everybody must leave except for the government attorneys and the panel's law clerks.
Before counsel, before counsel for the Jibrils, could you stop them?
Okay, they're going to stand in the hallway.
All right, just so they're available, that's all.
Want to make sure they don't leave.
Yeah.